Chairman of the Miami International Arbitration Society. Adolfo, the floor is yours.
Thank you, Sarah. Good morning or good afternoon, depending on where you're sitting. Thank you for joining us on behalf of Miami International Arbitration Society. It really is an honor and a pleasure to have with us Claudia Salomon. This is a conversation with Claudia Salomon. It's not designed to be a presentation. It's designed to be informal. And so in that respect, to the extent that you have any questions, anything you want to mention, please use the chat feature on Zoom that's in front of you. This program is about the future. A great deal has changed in the last year. Obviously, we've gone through a worldwide pandemic. The world has continued to operate. Surprisingly, arbitration in particular has, to some extent, thrived more than courts have. And so it's been a real eye-opening experience that we've all been through. It's also about the future because we have new ICC rules, but more importantly, we have a new president that's going to take over for the ICC on July 1st. First, to get a better look at the future, I want to go back a little bit into Claudia Salomon's background. Claudia is a graduate of Harvard Law School, graduated cum laude, and Brandeis University, graduated summa cum laude. She's a leading practitioner in international arbitration. She's known worldwide. She recently stepped down as global chair of Latham & Watkins International Arbitration Practice and hung up her own shingle to be an independent international arbitrator. Claudia is a member of the New York Bar, and she's also solicitor in England and Wales. As I mentioned, on July 1st, she's scheduled to become the first woman president of the ICC. It's the first time in the organization's 100-year history that a woman takes over. And so it really is a change, if you will, something that is momentous, something that we should take note of. And so that's why we're so excited to be with Claudia Salomon this morning. And so I'm going to start off with asking Claudia to what she attributes her success, because it is a very successful career that you've had, and it's not over, I know, but just wanted to ask you to, enlighten us as far as what have you done that's been helpful.
Adolfo, thank you so much for having me, and to the Miami International Arbitration Society for hosting this event. It's just a real pleasure to connect with you, at least over video conference, and I really look forward to getting to connect with everyone in person, I hope very, very soon. And I really hope the ICC Miami conference can take place in person at the end of 2021. Attributing success to any one feature, any one moment is, of course, very difficult. I've been very fortunate and certainly have had some significant luck in various stages of life, that's for sure. But I definitely was raised by parents who gave me the confidence to believe that I could accomplish anything, that if there was a hurdle in the way, then those obstacles were problems that needed to be solved. And I think that I have approached so many aspects of life with that perspective, even when I think about kind of moments late at night where we're trying to get a filing done or something, and of course there's a computer problem, or I was in far-flung places in a hotel that didn't really work well and didn't have a copy machine, so had to think about how I would print something. And I remember, well, there's always a way to do something. One of the solutions had been having, in essence, a secretary in the US fax me something, which was the document I needed. And so it was, in essence, copied. So I was able to have a hard copy, come up with any solution to a problem.
That's great. What attracted you to international arbitration, and what kept you invested in it? How did you get to that field to begin with?
International arbitration was not something I was focused on in law school. Of course, I know so many people now come into law school with that interest, or LLMs with that focus. I was actually very interested in local government issues and voting rights and election law long before that was even taught in many law schools. In 1998, I moved to Phoenix, Arizona, where my husband was going to graduate school. And the head of litigation at one of the firms where I interviewed said that international arbitration was the wave of the future. And his comments were really prescient, and it made sense to me in a context in which there was going to be more global trade. And so I began to work in mostly commercial litigation, but with a little international arbitration. And then really the transformative moment of my career was in 2001, when I had the opportunity to go to Prague in the Czech Republic on 5 days' notice, originally for a month, and I stayed for 3 years. My law firm at the time had been hired to represent the Czech Republic in what was, I believe, the largest investment treaty case at the time. And then once there, I worked on commercial arbitration and investment treaty cases all over Europe. I had a distinct memory of flying one day from Dublin to Athens. And at that point, it was as far as you could travel within the Eurozone. And my last summer there, I had 3 hearings in 3 months in 3 different cities, and then was able to really, from that point forward, concentrate exclusively on international arbitration.
Wow. So from Phoenix to Prague, that's quite a trek. That's great.
Yes.
One of the areas that obviously, because of your gender, a lot of attention's being placed on are the challenges that are faced by women in the area of international arbitration. And I guess I want to ask the question straight up. Do we, the world of international arbitration, have a problem as far as the entry and success of women in this field?
So in this role, I definitely take inspiration from Kamala Harris's comments that I may be the first, but it is really my responsibility to assure that I am not the last. There have been tremendous strides in increasing gender diversity in international arbitration, but we of course have a long way to go. I think back to when I took the bar, and I grew up in Richmond, Virginia, and actually started practicing there originally. And women had to wear skirts to take the bar exam in the 90s. And I remember even the day in the law firm where all the women decided to wear pants on the same day in the office. So it wasn't such a big deal for any one of us. We kind of bonded together in that context. So we've come a long way just generally in the way women are practicing. But of course, the number of women as equity partners in large law firms around the country has stayed around the same percentage numbers. And we obviously have significant room for improvement for gender diversity in arbitrator appointments and in so many other aspects of international arbitration. But I'm sitting on a tribunal now that's all women with 2 judges, one state court judge and one former federal court judge. There's a thread on OJMID this week talking about various tribunals that are all women. And what we're seeing now is a demand from the parties in international arbitration for their outside counsel to have diversity and reflect the in-house counsel teams and reflect the world that we live in. And they're also demanding that the arbitrators that are presented to them are diverse. And that's just an exciting development and absolutely essential for the legitimacy of arbitration.
Do you find that the international aspects of the practice make it easier or harder as far as bringing about gender diversity?
It's a great question. And I think it really depends on who you are. One of the aspects of diversity and awareness of gender occurred to me when I started working in Prague and when I've worked in the Middle East, that I became so aware that I was being treated as the international specialist. And my gender and nationality was not the predominant aspect at that moment, because I was viewed as the expert that the client sought. But I was so aware that the women I was working with locally were being treated very differently. And so I often hear people say, oh, what people are experiencing is so surprising because I don't experience it. Well, you may not be experiencing something because of the very circumstances you're in, but other people are because of the circumstances they're in. And so we really have to get outside of ourselves and see what's happening to others.
Great. You're assuming the role of president of the ICC and what we hope and pray is the end of the pandemic on July 1st. Yeah. And so I just want to get your thoughts as far as what you consider to be the greatest challenges facing the ICC at the time that you assume that role.
We are obviously in a very competitive environment for arbitration services. So my focus is really twofold. The first is that moment when parties are entering into a contract and drafting their dispute resolution clause. What is it that is going to make them, one, choose arbitration, but two, choose ICC arbitration when other arbitral institutions' rules are legitimately acceptable choices? I think over time, we're going to see a convergence in many of the rules, as we have already in even the last rounds of amendments to various arbitration rules. I believe the ICC service and quality that the ICC provides is second to none. And that's obviously going to be key. But ultimately, the clients, the parties to arbitration, are going to make a decision because they feel some connection to the ICC, that the ICC reflects their values and they view the ICC as their essential partner that they trust if a dispute arises. And that's absolutely my focus. The second area is, of course, service when thinking about that range of time from when a dispute arises to the issuance of an award, to assure that the clients of the ICC, the parties to the arbitration, expectations are met, we exceed their expectations, and we're operating with a client mindset, with a focus on being service to the parties to the arbitration.
I don't know if this question is will duplicate what you just said, but if you do, we can just went on. But I'm curious as to what your top priorities are in that role.
Well, I think I will have the opportunity to lay out a number of initiatives once my term starts. And of course, there's 3 more months left to Alexi Moore's term. And I think we will see a number of initiatives still getting rolled out. But I can certainly state that increasing diversity in international arbitration is one of my absolute top priorities. And a focus on diversity is broadly defined, not just gender diversity, age and geographic diversity. And I should note that Alexi's made tremendous strides in those arenas with achieving gender parity of the ICC court. Now there's a focus, rightly so, on increasing race and ethnic diversity in international arbitration. But we have to focus, of course, on LGBT. And emerging out of this pandemic, we have the opportunity and must indeed focus on the increasing disability inclusion in international arbitration.
I'm curious on the disability front. Do you find that in international arbitration it's more of a challenge, or less has been done than should have been?
We are at this pivotal moment. In essence, the fact that we are talking to each other through a screen shows that in the pandemic, we have in essence all been disabled. We can't travel. We've had to think about everyone's circumstances when deciding a procedural timetable and the way a hearing would operate in ways we never have before. We've heard people's dogs barking and children crying when we're in the midst of very important meetings, and we have greater empathy to everybody's situation at this moment. So we've come to realize actually that if you have limitations on your ability to travel, or you can't work 8 hours a day when that might otherwise have been viewed as inefficient, now everyone has the same perspective. I couldn't possibly sit in front of a screen for 8 hours a day. So we've realized we can be accommodating in ways that we've never focused on before. And in a moment where innovation and creativity are absolutely essential skills, we should be thinking about the people who have to be innovative and creative in their daily lives. So I don't know specifically that international arbitration has not addressed this issue as well as other sectors. But for me, this is a moment where we can really think about how to be inclusive, and we indeed must.
In a related question, I'm impressed by the number of young people, recent graduates that are interested in the field of international arbitration. I believe you got started with the ICC with the young division of the ICC to begin with. I'm curious what you see and how you see the role of a young practitioner, where sometimes it's difficult to gain the experience and the knowledge to succeed in that area. What do you see?
Lucy Reed certainly has spoken about the lack of a match between the number of young people interested in the field and the potential opportunities. That being said, it's really exciting to see so many people from so many parts of the world interested in this field. And you're right, I was the first chair of the Young Arbitrator Forum when it was only in the United States and not global. And I know Josefa Sicard Mirabel is one of the attendees of this webinar, and it was really her initiative, and she was the one who got me involved. And so I'm so grateful. So I encourage everyone to get involved with the Young Arbitrator Forum. The programs are typically free. You have this ability to connect with your peers globally, to learn so many skills and substantive aspects of international arbitration in a forum in which you don't need to be hesitant to ask questions and can build relationships and networks globally. I think that there are so many ways to get involved in international arbitration and then begin to build your own profile by thinking about articles you can write, volunteering to do work for various arbitration institutions that people may not want to do, such as newsletters or other event planning. If you've been working on a case and there's an interesting aspect of the case, then it's very easy to turn that analysis that you had to do in your case into a short piece for an article, and then see if there's a way in which, once that article is published, you can organize an event around that substantive or procedural question that you've just analyzed, and you become an expert on that, and you build on the skills and visibility that you're getting through those various steps. So I really am excited to see the energy that is in this new generation.
You touched, you more than touched, you went pretty deep into the virtual world and how much, living in the conditions that we're living has opened up possibilities. What do you see the future will be based on are there going to be more virtual hearings, for example? Is it going to be adopted as a matter of course? What are the opportunities? But also, what are the risks that we face as far as virtual meetings and hearings are concerned?
There's certainly discussion about whether we're ever going to get together in person. And I really love John Fellis's comment that, if you have a choice between Zoom cocktails and in-person cocktails, I don't think people are going to say, no, let's just, get together by video. The value of getting together cannot be understated. Those micro connections that we have, the micro interactions that we have, make us human. They give us the depth of connections, the opportunity to learn about people in ways that you don't have in a virtual setting. That said, in the context of hearings and the context of preliminary hearings and case management conferences, I do think the ease at which the international arbitration community has operated with these new technologies shows that the presumptions are flipped now. Before, we had to truly justify why a witness or expert should testify by video conference because of a health reason or travel or something, and opposing counsel always made such a big deal about it, and then you had to go to the tribunal, and that was because the presumption was everyone needed to be in person. Now we have to truly assess, do we need to be in person? And there are going to be evidentiary hearings and even case management conferences where everyone's going to say, yes, let's be in person. But there's going to be thoughtful consideration around that. And that's a wonderful development. I served as a member of the task force on reducing time and costs. And the irony is that the only way you could participate in the meetings at that time was actually being physically present in the conference room in Paris for the discussion. There wasn't even a way to participate by phone or video in a context in which one of the core recommendations of that task force was that preliminary hearings and case management conferences should be, new technology of and use of phone and video conferencing should be considered for at least those stages of the arbitration. So we've come a long way. and rapidly too. I mean, think about how fast everyone adopted. And that speaks to the nature of the international arbitration community. It is an innovative and adaptable community. And certainly on a personal level, I thought I could never read a stack of documents without them being printed out. And I've now gone fully virtual.
Wow. No, that's amazing. The we have participants here from Botswana, Peru, from all over the world, and it's just amazing how you can connect with anyone. So it's really amazing. One of the issues that used to be raised, I haven't really heard it that much because I think maybe it's either accepted or people just recognize as security and confidentiality. The concern that something can be recorded if you're not physically there. I'm wondering if you have any thoughts on that and ways of managing that risk.
Yeah, I mean, we're certainly seeing news stories of the ways in which video gets manipulated, and it's hard to assess whether someone actually said something when you're looking at a video that's been altered in such a way. Certainly at the start of the pandemic, when the ICC issued its guidance note on the conduct of hearings in the midst of a pandemic, we were very focused on the technological aspects and the concerns everyone had about, well, how do you address the possibility of a witness or expert cheating? Should you do 360 camera reviews in particular rooms to make sure that no one else is there, or there aren't notes posted throughout? Of course, you can do all those checks and still have somebody trying to do something. So much of our profession is indeed based on the core aspects of honesty and expectation of everyone doing what they're supposed to be doing. And so we just continually have to watch the techniques people come up with to try to cheat and respond to those, anticipate those, and continue to focus on cybersecurity as a priority, and of course, confidentiality when that is sought by the parties.
So at the beginning of the year, the ICC introduced new rules on a number of different fronts. One of them were remote hearings. I just wanted to get your overall impression of what drove those changes and why they were adopted, why they were implemented. Not necessarily go into a lot of detail, but just want to pick your brain on that.
Sure. The new rules went into force January 2021. They really were focused on continued assurance that the ICC has best in class, and that in particular, the multi-party, multi-contract disputes can be even more efficient. So some of the amendments addressed joinder and consolidation. There was a continued focus on the expedited procedures, and the threshold for cases that fall under those procedures was raised from 2 million to 3 million. And that has been a very significant success, where the cases that fall under those thresholds, but even cases where the parties have opted in when the threshold is even higher, can have an award issued within 6 months. And we have really seen the cases achieving those deadlines. So I think in some respects, the amendments were in response to various tactics that have arisen and specific cases and challenges and issues that have arisen. For example, the rule focused on whether the tribunal can decide to exclude counsel because there would then be a potential conflict with the arbitrators. That rule is not designed to impose greater power of the tribunal and for it to be wielded. The rule, in my expectation, is going to mean that the power will likely be is unlikely to be necessary, because the tactic of trying to introduce new counsel as a way to delay an arbitration is unlikely to be successful and thus unlikely to be tried now. Similarly, the rule that the court can appoint all the arbitrators is not designed to be utilized. It's designed as a backstop when the clause has such inequity that it would result in an arbitration that would likely to be unenforceable. That instead of the court exercising its inherent power, the rule makes clear that the court has that express power to address that issue.
On the rule that basically makes it the panel's decision as to whether to accept a change in party representation, was that a recurring problem that the ICC was seeing, that tactic was being used to introduce new counsel that would create a conflict? Or
I would say it was a significant problem, but certainly it occurred at the ICC, and then from articles and other literature, we know that that was a tactic, or has been a tactic, that has been used under a wide variety of arbitration rules.
it's my impression that historically, and correct me if I'm wrong, it's only my opinion, it may not have validity. Historically, kind of what there were general guideposts to how you operate in the international arbitration space. Reputation matters a great deal, and maybe what made people behave or act properly was ensuring you don't want to develop a bad reputation in the space, because it can really hurt you and hurt your clients in the future. Number one, do you believe that's correct, that observation? And number two, has that changed recently?
Well, certainly I am of a firm believer that what you have is your reputation. And so it's absolutely essential to preserve that, and you could lose it over something so small that actually is so significant. So when people talk about kind of the arbitration world of the past and the arbitration world of the present, and how we have so many more soft rules, or is there a need for more guidance on behavior? I think what we have in essence is a procedure for resolving disputes that has gained popularity around the globe. And when you look at the statistics of the number of countries where parties come from, where arbitrators come from, where arbitration is seated around the globe, you absolutely see that this is not a club. This is a global community. And so the notion that there are expectations of how someone would behave is in a context in which there's probably so many different types of expectations. And so it's good to articulate those expectations now in the context of soft rules and even the rules themselves.
It's interesting because it's got to be a hard issue to manage. Essentially, I think the area has grown. The acceptance of international arbitration now, I think, has become substantial. I don't have any figures. You probably do, but it's interesting. Can you, how do you balance that? How do you balance do you go into a highly regulated course, or do you basically ensure you maintain the importance of having good programs, having education, having underscoring the importance of reputation? So it's interesting. You wanted to say
and
something?
all to be balanced with the flexibility of arbitration being what is one of its essential features. So I think you have to also think about this in the context in which if we're looking at arbitration from the clients, with a client mindset, with a client perspective, we want the process to match the parties' expectations. The fees and costs should be commensurate with the amount in dispute. The time should also be commensurate with the amount in dispute and what the parties expect. That being said, when a dispute arises, the parties are rarely in agreement regarding the process, because the process itself is viewed as a way in which one party has a tactical advantage, or the desire of the process differs for the parties once that dispute arises. So the parties themselves have to balance how much specificity they want to have at the time they're entering into the contract versus the flexibility shaping that process when the dispute arises. One rarely has the crystal ball, of what side of the equation you're going to be on when the dispute actually arises. And so often the parties do opt for less is more when they're drafting the clause, so that there is the ability to shape the process. But for me, one of the key things I'm focused on is thinking about ways in which the clients can stay actively engaged or be actively engaged in the arbitration. By clients, I mean the parties, what has been who are described as the users of arbitration. And there's so many ways in which if they are actively engaged in that process, then I believe their expectations of the process can be heard, and then they actually, those who are involved are paying more attention to the parties themselves.
I want to bring you to Miami.
Great.
And hopefully you'll come soon.
I wish I could come right away.
One of the a conference that the ICC has had every year, I was at the first one. It was just 20 of us at Biltmore a long time ago, 20 plus years. It's grown into a very large event, and I wanted to get from you what your opinion or views are on Miami as an arbitral seat, and what's our standing?
ICC Miami is definitely the most fun ICC conference around the globe, and hope that we can gather in person at the end of this year, and if not, certainly next year. It's grown so significantly, and that is a reflection of the work that's been done by the arbitration community in Miami. And for that, huge applause for building Miami as a real seat for arbitration. I think one of the things we're going to see in the future is an expectation that arbitration take place closer to where the parties are, with arbitrators who reflect who the parties are as well. And in that respect, while we are seeing great strides in the legal aspects of arbitration seats around the globe, including in Miami. And so I think there's going to be in the future less attention to the most traditional arbitration seats, and we're going to see arbitration taking place in many more seats around the globe, including Miami. And that is a good development.
And this is coming from a New Yorker, so I'm wondering why you think it's a good development.
I think it's a good development because there is an aspect of international arbitration that nonetheless parties want to, and for the legitimacy of arbitration, need to feel that the process is something that reflects who they are, as I said, but also that they feel connected to the process. And if there is the opportunity to have an arbitration closer to where you are, then there is no need to have the expense of traveling. And so the choice, the limited choice of seats in the past was in an assessment of the strength of those seats under a wide variety of criteria. Of course, if you have one party from China and one party from the United States, where the arbitration takes place is not going to be close to home for both parties. But if you have two parties from Latin America and they're choosing to have their arbitration in London, they're making that decision for various reasons, and some of that could be historic. If they have the opportunity to seat their arbitration closer to home for both parties, then we do address some of those issues about time and costs and process that are essential, as I said, to the legitimacy of the process.
And true to your word, I want to make an ad for our friends in Atlanta. You're actually scheduled to be provide a lecture on April 22nd at Atlanta's annual meeting, as I understand it, for Atlas. And so Shelby Grubbs in Atlanta asked us to announce it. So this program isn't done, but you can connect to that program on April 22nd. So you definitely are, going around and connecting with a lot of different jurisdictions. Are you doing that consciously to try and raise the profile, or what do you see that as your role, as the role of an ambassador? Or?
Especially in the United States, it is essential to connect with practitioners and in-house counsel all around the country. The Fortune 500 businesses are not just located on the two coasts of the country, but neither are parties to arbitration. I mean, SMEs, small and medium sized enterprises, are engaged in global business, and smaller disputes are a very large percentage of the total caseload at the ICC, along with the total caseload of lots of other arbitral institutions. So for me, it is absolutely essential to connect with these communities and with the clients of ICC around the country and, of course, around the globe. And I'm somebody that I mentioned, I grew up in Richmond, Virginia. I worked for several years in Phoenix. And so for me, I know and see the growth of global business arising, not just in Manhattan, but truly around the globe, and want everyone to understand and feel that the ICC reflects their values and that there is some connection there.
We have a few questions.
Great.
I have other areas I would love to get into, but I want to make sure that the audience is able to have questions answered. And we received one before the program from a Peruvian attorney named Jesus Ortega, and he had two questions. He first asked, what are the tangible possibilities of an LLM students in case they successfully complete the program at the ICC?
There are internships available at the ICC in New York and also in Paris and elsewhere. So certainly encourage lots of young people to apply to those. I think they are valuable experiences for those who who work there. Certainly getting to see the way the Secretariat operates and the way the court operates. So certainly encourage people to apply. I saw someone posted that the ICCYF is seeking applicants for the regional representatives. So encourage everyone to apply for that if they are age eligible, which I'm certainly not anymore. So, there's fantastic programming available. Most of it is free for younger practitioners, and really think those are valuable ways to get involved.
Great. My predecessor, Luis Onatin, he was the former president of MIAS. He's asking, He says, the ICC is many times perceived as costly as compared to other institutions. The ICC seems to have a large share of high value cases in which cost is not an issue. But the ICC has also revised the rules for expedited arbitrations for lower valued cases. How else do you think the ICC will try to combat the cost issue in selling its services?
Frankly, I see the cost issue as an absolute myth, because one of the key ways I can speak to that is the number of complaints I have already received from arbitrators about their fees for ICC arbitration. And I'm not hearing that complaint from the parties to an arbitration. But that being said, I think the ICC's fee structure, when I was counsel, had great value for clients, because what I hear from clients is they want predictability. And that is one key aspect with the ad valorem system, that I could say to the clients that based on the amount in dispute, the fees are going to be in this range, and they could budget for that. I think the perception of the cost of ICC arbitration is based on the fees being paid up front. But when you do talk to arbitrators, they all say that their hourly rate when they do ICC arbitrations is less than when they do arbitrations where they can be paid their hourly rate. And so that actually means that the fees and cost for the ICC and the arbitrators is less. You're just paying it kind of in larger sums at one time rather than over the course of the arbitration. But I should note that installment payments is an option at ICC, and parties do take advantage of that. I think the expedited rules are a great way to address the cost of arbitration and the time associated with arbitration.
It's interesting because you observed earlier how you're seeing more convergence in the rules. The rules tend to be very similar, but the pay structure of the different organizations are very different institutions. Just so it's I see the point that you raise is the predictability. The one thing you have with the ICC is the ability to go into the cost calculator, and you can tell a client this is how much it's going to cost you. That's a huge difference.
And it is the value of ICC arbitration. And we talk about the court scrutiny, and that I think has a bit of a mysterious aspect to it, but kind of an essential feature of ICC arbitration is the ICC court, comprised of court members from around the globe, review every draft award before it is finalized. And that means that the reasoning is set out more clearly in ICC awards, and the awards are drafted in such a way that they are more likely to be enforceable. And I do think that that value aspect is something that the parties to ICC arbitration understand and consider to be a true value.
Another question, William Hill, well-known Miami international arbitration practitioner. He asked, what are your suggestions for getting involved in the ICC?
So if you are below the age of 40, then definitely get involved with the YAF, the Young Arbitrator Forum. There are so many committees at the ICC with the US National Committee. And so there are the regional subcommittees, and then there are also the sole practitioner subcommittees and the in-house committees. And so those are great ways to get involved. So it would be wonderful to reach out to the subcommittee chairs, or to Merritt Crisula or Nancy Thevenin, who works with the USCIB National Committee. And we would love to have you get involved, as we're really building the connections to in-house counsel in particular and practitioners all around the country.
And William Hill points out that unfortunately we've aged out on the but we wish we were. We're still like dreaming. I have a question more about as far as the role of academia and international arbitration. Do you believe it's more important in the international arbitration field as opposed to other areas, say general litigation or corporate?
Whether people need an academic background in the field?
No, the participation of a lot of educational institutions. So, universities, I know University of Miami, obviously we're very proud, and FIU. So we have a very large group in Miami, University of Florida. One of the things that in Miami, we believe has been important. It's just having a lot of university support, both on the student side, but also the professors. Just about all the local universities are active with MIAs. I know New York, obviously, with Columbia and NYU, Fordham, they're important, players. And I'm curious how you see the landscape.
I do think the academic programs for international arbitration are vital. And I would say that we are still in the mode of education about the value of international arbitration compared to litigation in the United States and absolutely globally. I mean, I have had so many conversations when I was in private practice as counsel with my colleagues who were drafting dispute resolution clauses and with clients about, the fundamentals of why are you choosing international arbitration rather than litigation when, if as a US party, you have the negotiation power to insist on litigation in the US when your counterparty may not have any assets in the United States. So kind of the fundamentals of the benefit of international arbitration still need to be communicated to people who are not just practitioners in international arbitration, but everyone on the transactional side who is involved in drafting contracts. Our international arbitration is a specialized area procedurally and substantively. And what I think is essential in the academic programs too is really looking at the substantive area, and there's going to and new frontiers in that arena as well.
Well, it's very interesting, and that's the part where I just see a bigger need as opposed to we all in the U.S. go to law school, we take the bar, and your first year courses tend to be what's focused on, and this is not discrete, and it's obviously a growing area, an area that's thriving, but the importance of just having that foundation and of having further and further study, more research and understanding. That's the other beautiful thing is obviously the drawing in students from all over the world, and that to me is a beautiful thing, if you will.
I love that, and I just kind of in response to the previous question too on how to get involved, I should really just mention the Icc Institute as well, and Melida Hodgson, which is a name many of you will know in Miami, is one of the vice chairs of the Institute. So really wonderful to have her in that role. And that is, the Institute really puts on substantive programs and is looking at substantive issues and procedural issues around arbitration and international business law. And so that there's a membership application that you can submit, and that's certainly a great way to get involved and kind of have that academic learnings continue long after you're in law school or in an LLM program.
So that's all I had, but before I cut this off, I wanted to ask you, did I forget to ask you anything? Is there anything you want to say before we finish?
the questions have been fantastic, and so glad that we have questions from the audience too. I really want to communicate that my virtual door is open. I am gaining so much from hearing from people globally and at all stages of their career. If people have concerns or questions, I certainly want to hear from you, and really hope that we have the opportunity to connect in person in the near future.
So the one thing I did forget to say, not really, I just wanted to leave it to the end, is to congratulate you, because it's
Thank you.
it's quite an achievement to become president. It's also a huge responsibility. It's so great to have you. You know, somebody, a girl from Richmond who got into international arbitration via Phoenix and Prague. It's an amazing story, and the fact that it's you know, you're going to be working hard in Paris in the premier arbitral institution. It's just a wonderful story, and thank you for letting us get to know you a little bit better. So it's wonderful. Thank you for accepting the invitation to join us at MIA's. It's going to be great to host you next time you're in Miami.
Fantastic. Thank you so much. I really look forward to it. And again, really just an absolute pleasure, and so appreciative for people attending and for you having me today.
Great. Thank you, everyone.
Thank
Take
you.
care. Bye-bye.
Bye-bye.